Hello, everyone. It's great to be here one more time today. My name is Gary Fowler. I'm the CEO, president, and founder of GSD Get Shit Done Venture Studios, a premier AI and quantum venture studio. We believe that intellectual capacity is evenly spread around the world, but opportunities are not. I'm a serial entrepreneur with 17 companies under the belt. I've been involved in several unicorns, Click Software, which was sold to Salesforce for 1.35 billion, and also Eva.ai, one of the first AI HR tech companies. So with that, I have an incredible guest today. Andrea Milano is here. Andrea is a lawyer. She's with Pillsbury, one of the world's most respected law firms. She manages some of the most complex employment matters in the country, from wage and hour class actions to discrimination and ADA litigation, to labor relations, large-scale workforce strategies, and high-stakes negotiations. She's represented clients in federal and state courts nationwide in private arbitration and across industries, including technology, hospitality, and healthcare. Her experience ranges from navigating 60,000 person class actions to securing more than 1 million in concession as a chief negotiator, advising companies through everything from buy-side and sell-side transaction to NLRB, National Labor Relations Board challenges, to managing reductions in sales forces with both legal precision and human empathy. Love that. Today, we're going to explore how employment law is not just a compliance function, but a strategic superpower for founders, CEOs, and executives who want to build resilient, high-trust, billion-dollar cultures. Andrea, it is great and an honor to have you here today.
Gary, thank you so much for having me here today. I'm thrilled to be here.
I was, just by going down through your bio, I was like, have you been in this like for 40 years? It's unbelievable.
15, so not nothing, but
you know what I mean? It's amazing. So, going down through this, you've gone down through and, you've seen a lot of things. But what really inspired you to pursue employment law as opposed to other types of issues, litigation, et cetera? And why does it matter so much in today's corporate landscape?
yeah, absolutely. So I feel like I've been an employment lawyer forever, and my entire legal career has been employment law. I went to the Cornell School of Industrial and Labor Relations, and I settled on that because they sold me on I got to kind of major in a bunch of different things all at once. It was part law, part business, part psychology, part economics, part history. I loved that. I loved that I didn't have to choose. And I feel like now I still get to do all of those things every single day. I love that mix. And I feel like as an employment lawyer, I am always balancing all of those things. It's law, it's business, it's the human component. And that is really what has drawn me to employment law and kept me here. I think my favorite thing about employment law is that since everyone has employees, it's so relatable, and I can work across industries, I can work across client teams. I average working with 200 firm clients a year. That's huge, but it just goes to show how widespread these issues are. And so I love being able to work really with everybody in the firm, with so many clients. It keeps things interesting, but at the same time, it is providing this consistent service to anyone who needs it. So in terms of, why does employment law matter? I think, from a cheesy aspirational perspective, employment law matters because it's not your what, but it's your how. It's who are you as a corporate entity and how are you going to treat the people who get you there? But more practically speaking, employment law is so important. From my perspective, an ounce of prevention is worth pounds and pounds of cure when it comes to avoiding lawsuits, securing funding, minimizing distractions, minimizing bad PR, all of those other risks, and so that you can stay focused on your bottom line. And I think that's really probably the crux of what we're going to talk about here today, is kind of how we can use employment law to keep the founders focused on doing what they do best.
Are there common culture or legal issues you see emerging again and again in fast growth companies?
Absolutely. I think one of the most amazing things about the startup clients who I work with is just their blind optimism and their sole focus on what they are setting out to do. And I think that's incredible. But you've got to bring some other people along for the ride, right? So I think there is a necessary element that when you are the one who is risking it all to put it on the line. You have to believe you're going to succeed, and a lot of the details fall to the background. But the optimist built the airplane, the pessimist built the parachute. I'm not telling you not to build the airplane. I'm just telling you, here's some things to take on board, right? So
Yeah, a parachute.
yeah, exactly. A parachute, extra batteries, a snack. Like let's just make sure that airplane is as equipped as it can be. And so I think, doing some of the detail work, being the person who it's not always fun, but thinking about the worst case scenarios. It's I see employment law very similarly, I think, to prenups in marriage, right? You might not want to think about it. It might be awkward. What if things go wrong? But if something does go wrong, you're really happy it's there, and you're really happy you spent the time on the front end getting it in order.
No, I agree with you 100%. You've managed discovery in a 60,000 person class action suit. What does it take for a company to survive and win? Because it's tough, right? Going through that kind of litigation, at that scale. So what does it really take? What's important for them?
Yeah. Well, I'm glad I got this question in advance because my gut reaction was tequila, but that's not a good answer. So the things that actually get you through, I think supreme organizational skills and really strong operational knowledge. You need people who know, and this is not just during the litigation, this is during the time when you are operating your company so that you're prepared to respond. But keeping track of documents, keeping track of organizational decisions and policies, and having people who know what happened and why, so that you can craft your defenses, craft your arguments, and move the litigation forward in a way, keeping in mind what's most important to you as an organization, what fights are worth fighting, where is it worth standing down, what can change, what's bet the company. And so having a team that has that intrinsic knowledge and really the context for making those decisions. And then I think the second thing that you need is a legal team you trust and get along with. You're going to be in the trenches. Things are, it's unpredictable. Things change a lot as you go through. You need to be able to trust the team that you're working with, that they're doing good work, that they have your best interests in mind. And it's a combination of legal and operational, right? It's what matters to you. And are you working with a team who can get that done?
No, I mean, you got a great team. I have some friends, obviously, that are part of Pillsbury and amazing, actually. Good, great people, right? And I'm not just saying that. I'm saying, from the inside out, good people that really look after your interests and cover
Absolutely.
you, watch your back. So what does it take for a company to survive and win litigation at scale? We talked about it a little bit. And then this thing with ADA accessibility and accommodation claims, I'm hearing more. In fact, I heard today that if you don't have websites up that are compliant, and most small businesses, they're just trying to survive, Andrea, what I mean? They come up and they don't even have a job and they're trying to live, but you're getting this stuff coming at them. How
Absolutely.
do you deal with it? It's like, there's ADA accessibility and accommodation claims and more common and almost predatory, actually.
It's true. And I handle a fair number of ADA claims based on allegations of company websites. And those are super frustrating because the vast majority of clients I'm dealing with in that space are trying to have accessible websites. And so I don't think there's anyone who's going to sit here and argue that someone who is using a screen reader or is visually impaired shouldn't have access to the website. But the level of intricacy and detail is really hard. And it gets even harder when you have third-party content on your website that you can't control, or you're working with website vendors. It's a really complex.
It's crazy though, Andrea. I mean, on some ways it's great, but we're going to put, little companies out of business, right? If they start getting litigated against and they're a startup with a Series A that's just surviving. How does it, I don't know. It doesn't seem fair, to be honest with you. It's like, it's almost like the spirit of America doused, but how do you, it's tough to deal with that kind of situation. How does the small companies, because I've just had a conversation with a couple myself, right? And they're really concerned about it.
Absolutely. It's definitely a concern, and it's definitely something that now needs to be on the compliance checklist for new companies. It has to be something that you're thinking about from day one, because there are a lot of plaintiffs who are just going through and testing websites and filing lawsuits, and they see that they have a role in preserving accessibility, and I won't argue with that, but I appreciate that it is absolutely a cost you're not counting on. And so working with vendors, there are different website applications you can use. There are different vendors who you can retain. And I think it just has to be part of an ongoing compliance strategy. I'm seeing more and more companies, it's just routine, or you have, there are different things you can put on the website that will run automatic checks. And so then you follow up with manual checks at a, slower but still regular cadence. But that is becoming a larger area of law that we're seeing litigated. Absolutely. And then you turn to the ADA claims that are inside your organization with your employees.
Yeah, exactly.
Right.
It's like, the thing is, it's almost like, it's tough to do business, right? People just throw up their arms and say, listen, what happens if they come after you and you're a small company? What do? Go out of business? I mean, like, seriously,
I hope not. I try my best to keep that from happening. I think having good policies on the front end, a lot of proactive work, dealing with things when they first arise instead of ignoring them and hoping they go away. Spoiler alert, they never do. And with the ADA claims, I think it's about having strong policies, strong communication, and then well-reasoned decisions. I'll say one thing. This probably won't make anyone listening happy, but I think one thing that can complicate ADA requests is unlimited PTO policies, and I think that's another piece of this: no good deed goes unpunished. We're just trying to get by, right?
And that's the thing. So that I always thought about that. So if they have unlimited PTO, just hey, listen, I just went off. You know what I mean?
Right.
And how could you say you can't do that?
Right. Well, and it's generally not even somebody trying to be malicious. It's just someone who thinks I can handle it. I'll just go to my doctor's appointments in the morning and I'll work in the evening, or I'll take care of my sick relative and I can still get everything done. And it works until it doesn't. And then there's performance issues. And the reason why we have leave statutes and why we give leaves of absence as accommodations is so that employees have the time they need, and then when they show up at work they can be committed in doing their job to their full capacity. And so sometimes that balancing act can just be too much. But the problem is if somebody has taken a lot of leave already, then you can end up having done all of that. You can get yourself into a performance management situation. And then also you will then have to start the clock over for the leave in accordance with the statutory entitlements. So I think it's really important when you don't have an unlimited PTO policy, usually these things just come up sooner and then you can deal with them more proactively from the start, as opposed to being behind the 8 ball and having to play catch up on those.
No, I love this. Just on the ADA thing, I think I've heard so much about it in the last couple of weeks. I think it's like, so how important on a 1 to 10 scale is it for companies? Let's say it's a small company. They graduated from Cornell. They're starting a little company, right? There's a couple girls and a guy, and they decide to start a company together. How important is it for them to get this stuff right from the beginning on this ADA with color and contrast and all those kinds of things on a 1 to 10 scale?
It's hard for me to say any compliance isn't very important. And I think it's easier to start out compliant than to have to play catch up. And with statutes of limitations and look back periods, it's easier to get it right from the start. But I never want to discourage anyone from taking steps to fix a problem. Like, you're never too far gone, right? So if you didn't do it from day one, but you want to do it now, let's do it now. So the best time to do it was yesterday, but the second best time is right now. And so I think that's the way to approach compliance and remediation.
I think we could do a show just on that, honestly, because so much fun. There's a lot of startups are really concerned because of having people contacting them. So I think that would be a show in and of itself. But anyhow, what should companies understand before they find themselves in trouble with these things, these claims? What should they do?
Sure. I think being consistent is really key. I also think that having reasoned decisions or reasons for your decisions is very important. So, another accommodation that we're seeing a lot right now is requests for remote work. And some companies are fully remote and it doesn't matter, right? But if you've got a hybrid situation or you have certain employees who are fully remote and certain employees who aren't, those decisions, when the requests come in, are going to be harder to justify. Sometimes it's easy, right? If I'm running a hospital, the RNs have to be there. I might not care if IT's there, right? IT could be sitting anywhere, but if you're providing patient care, you got to be in the hospital. But there's other considerations, softer considerations, right? You want to be building a culture. You want people in for collaboration. You're paying for office space. But where are you drawing those lines? And so I think being consistent and having guidelines so that when these things come up, you're making consistent decisions is a key to avoid trouble. I think a lot of trouble in the employment law realm comes when employees feel like they're being treated differently. And then we're all human, right? It's when you take something personally, you have to find a reason why it happened. You have to be able to explain it away. And it's hard to accept that the reason is something, I wasn't doing a good enough job or something, right? It frequently then becomes, it was because of a protected characteristic. And so we can avoid those claims of favoritism if we are treating people consistently from the start and the differences in how we treat people are well reasoned and well communicated.
What, if you're going down through it, when does a simple employee issue become a legal wildfire, and what, legal warning or what early warning signs leaders often miss? So when does it become a big problem?
Yeah, I think problems get bigger when they are ignored. And I think that employment law issues that are interpersonal tend to, spiral on themselves. And we see this frequently when an employee makes a complaint, and then it's not the complaint that's the problem, it's the response to the complaint, and then that triggers the retaliation claim. So whatever the original concern or complaint was, whether it was, valid or well-founded, then people start behaving differently because the complaint was made, and either people are on edge or people are offended, and it's not always capital R retaliation, right? It can just be that we're all human, and or I got in trouble for telling jokes that were a little off color, so now I'm super conservative and I'm not telling any jokes or saying anything remotely funny. And then people sense that difference. People might feel excluded, and so then it's a retaliation claim. And so it started out as this little thing, and now it's a bigger thing.
Wow, that's amazing. That's
Yeah,
amazing how
yeah.
that can be.
The other thing I would say that we see is performance issues. You would not believe how many times I get calls that we need to fire somebody, they're terrible, we've got to let them go right now. And I say, okay, where's the documentation? What did they do wrong? What have you said to them? And the answer is nothing, right? And so managers don't want to have the hard conversations. It's awkward. You don't want to tell somebody that they're not meeting expectations. And then it's a huge surprise. And sometimes they've even gotten good reviews because, oh, I didn't want to negatively impact their comp. I didn't want these, negative consequences. But what you really did was you didn't give them a chance to learn or improve. And so now we're in a situation where we have to figure out how to handle it, where if we'd been documenting it from day one, maybe they could have improved, maybe not, right? Some people just aren't a good fit, but we don't know because now so much time has passed. There's so much water under the bridge, and we have to figure out what to do now. So I think that's another problem, is not having the conversations early on that could either lead to improvement or form the clear path that leads to termination not being a surprise.
You regularly help companies craft, here's the challenge. Again, I'm going back to startups, right? You help companies craft handbooks and policies and training, but most startups, they don't even know if they're going to exist tomorrow, you know what I mean? Or in a month or 2 months. And rarely do they ever do the handbooks and policies. When should they do those, right? So somebody forms a company. When should they start working on handbooks? When there's 3 people that are the co-founders of the company. When does it start?
I think this kind of circles back to find a lawyer you trust and find a lawyer who works with startups. We have the documents for you from day one, right? And we can help you. You need different policies when you have 3 employees than when you have 20. And we can have a conversation. Where do you think you're going to be in a year? I can give you a handbook for today, and I can give you a handbook for next year. But this is what you need today for funding, for looking at investors, right? This is what they're going to want you to have on day one. I think earlier is better. That's what I'll always say. But, I'll also say here, go to a lawyer for these things. I have gotten more and more handbooks from ChatGPT, or I guess I shouldn't name names, that are clearly, AI generated. And I promise you, I can get you a handbook faster and cheaper than I can review an AI generated handbook. And it was kind of an iterative process for me. The first one I reviewed, I'm like, why is this in here? What are they trying to say? Oh, this is, B-roll AI generated, and it just has to come out. But if you're working with a firm or a person who you trust, we're not going to overbill. We're going to get you what you need, but you can trust what you're getting from a source, right, that is vetted. And I think that's true for the handbook. I think that's true for all of your kind of startup onboarding documents. And then also a good lawyer who you trust will help you know what you can do on your own and when to come back, right? So we see this a lot with employee versus contractor classification. And I personally want to know when you're hiring someone as a contractor, especially if you're in certain jurisdictions like California, where that can be like a big red flag. But I can have a conversation with you when I give you the template and say, these roles that we've talked about that you're considering, good to go. If you're hiring someone in your C-suite, please call me first, right? So it's trusting that I'm not going to be looking to hamstring you, but you're going to come to me so that we don't run into problems down the road.
How does it work? Like, there's these sites like Upwork out there, and, so people use those sites, right? But what happens if they are in California and there's a California person and they hire them through Upwork? Does that change the game?
So having an employer of record, I think there's a lot of those payroll companies out there. And, if you find one that works for you, that's great. They generally have a lot of limitations on their legal representations, right? So I think that is a great place to start. I'd much rather review an EOR handbook than an AI handbook. But either way, I think you still want somebody on call. You want somebody on the bench. But I work with companies who have EORs all the time, and I think they can be really great for small companies who don't want to have to deal with all of the admin burden.
So what separates organizations that thrive to stumble? We talked about that. If you could give a founder 3 must-have employment policies on day one, what would they be? And this is for all you startups out there around the world that are looking at places like Silicon Valley. What are those must-haves that you say you got to do this if you want to not have challenges?
Absolutely. So number one is a very solid proprietary information invention assignment agreement. I'll probably call it a PIIA, but whatever version of the NDA, restrictive covenant, proprietary information agreement, that is your ticket. And that is super, super important to get right. So regardless of the non-compete rules in whatever jurisdiction you're in, you can always protect your IP, and it's so important to do that. So that's the number one thing. And I think that's probably the top request that we are getting right now is like more than an employment agreement, more than an offer letter, we need the PIIA. And investors are also really looking for that. So that you want on day one.
Got it.
Number two, I think you want a compliant consulting agreement with an understanding of who that can apply to. I see a lot of misclassification, and that can be a business decision, but I want you to be making informed decisions and not just, making people consultants because that's what everyone does, because you don't want to be the one who gets hit with that. So if you're making a business decision, we can live with that, but let's set you up for success with your consulting and classifications. And then number three, is a document destruction policy. I have seen, especially over the past year or two, we are now transcribing every meeting, we're recording every meeting, we are making a lot of evidence. And I'm thinking about if I had a 60,000 person class action right now with a company that recorded and transcribed every meeting. Oh my God, that would just be so much data. So I think it is great that that technology exists, and I know it's the fun, cool new thing right now, but having a policy where you're recording or transcribing only what you really need to, and then getting rid of everything else, getting rid of Slack messages, the things that people reduce to writing in today's world, blows my mind. So I think a document destruction policy where you're keeping what's important, but getting rid of what isn't is also really important.
No, that's fantastic. So, what's the most common mistake companies make when they scale rapidly and, they're growing because you're so busy, you don't look at it till it's too late. But what is the big mistake that they make from your perspective in terms of all this? And, you've led investigations, wage audits, high risk reviews.
Mhm.
Uh, w- if you could go out there and say, this is the one thing that they do, don't do this. What
Yeah.
is it?
It's I guess it's two-piece, but one is not paying their founders or their early employees and just saying we'll wait for funding. And then number two is just a lack of documentation. And that I think is particularly true when you're mixing friends with business and going into business with your friends, but not putting in writing what the actual terms of the agreement are. And then if something goes sideways, or even if something doesn't, right, you're still going to need to do that on the back end. And then people remember things differently or try to renegotiate the terms. And so getting that right from the start is super important.
Yeah, I know somebody's going through that right now, right? They actually, they thought they had this agreement and they didn't keep a copy of that, and it's a mess. It's a bag of
Hmm.
snakes actually to try.
Hmm.
And how often does it happen? Like, of the percentage of the companies that you talk to, how many of them really go down through and line everything up in advance? Is it half of them, or 25%, or most of them? What is it? Because it seems to me the ones that I talk to, very few of them really think about it in advance.
Yeah, I would say it's probably not a fair statistic because I tend to see the companies who are in trouble. But I would love to see more companies before that happens. But I think few are doing it, and most could stand to improve.
So performance management and termination are emotionally charged. What do corporate leaders consistently underestimate about doing this correctly and legally? Because there's all kinds of stuff, right? Age
Yeah,
discrimination, et cetera. I had somebody say one time that they didn't say age, but they said succession planning.
right,
I mean,
right.
how does it? Where's the line between what can you say and what can't you say, right?
Yeah. No, it's a great question. So I would say in terms of performance management related terminations, when somebody's affirmatively not working out, less is more. Um, Generally, employment in the US is employment at will. And again, we should have good template documents and onboard people so that we are making use of employment at will where it's appropriate. But you can fire someone for any reason or no reason at all, as long as it's not a violation of the law. And so much like a breakup in a romantic situation, it doesn't help anyone to go through and tell the employee every single thing that they did wrong. If we've done things the way we should have, if we've been communicating, it shouldn't be a surprise. And so a message that performance has not been up to standards, this isn't working out, today's your last day, if you're offering severance, what the severance is, and then saying if there's additional questions, we can follow up next week, and then let the employee bow out gracefully, right? Like, you are delivering really terrible news, and nobody's ever going to say, wow, what a thoughtful termination move, right? So you have to be like, you have to own that you are the bad guy in that moment, and you have to do it with empathy and dignity, and less is more. But then I will also say, for this has been a really hard year for layoffs, and it's shaping up that I think that's going to continue. And there's just no way to make layoffs easier to manage, right? Like we can work through it, and it is a privilege of my profession to help companies through those really hard times, but I routinely have to counsel those clients like, this feels terrible because it is, right? And so
I
I
mean,
think
no good way, the situation is you go down through your business and,
right,
and you're right about it. It's not, pointing out to somebody all their misgivings or their weaknesses is not going to help them in the
right,
situation. You obviously hired them because they did something right. Focus on the good stuff and not the bad, right? And,
right.
you
And
don't need to.
that doesn't mean don't fire someone. That doesn't mean don't do layoffs if that's what your business needs. But we do need to be treating people with dignity and respect and care. And also for the employees who are left, right? To make sure that they still know, this was a hard day and we're going to move forward, but we can continue to trust this organization, and we stand by this employer.
No, it's fantastic. I love talking to you about these things. I love it because my head's spinning right now. Um, so, you got the other side of it. You've got labor unions, you got workforce dynamics, you got all kinds of things mixed into it, like you said. So you've got clients through union organizing efforts and complex collective bargaining. How's the labor landscape changing right now? I mean, is it still like that? Or there's still the union? Because I hear about it every once in a while, right?
Yeah. So I would say union and labor work is somewhat inherently political. So I'm going to try to stay away from politics, but I will say starting in 2016, there was a significant effort to organize nonprofits and that sector. And so that has been going on for the past decade. And we've recently seen, I think, in response to the current administration, there is a push by unions to get employers to commit to the employment protections that employees feel like they're losing under the current administration. So we're seeing a big push for immigrant rights, for protection against discrimination, for commitments to DEI. And so I think there is a lot of that going on currently. I think we are going to continue to see unions pushing non-traditional industries. And while I don't think startups are next on the block, I do think bigger tech could be, especially as employees and Gen Z and just all of this momentum keeps building.
Then companies, right? It's tough. When I was young, I was in the retail clerks union, and I remember it. And can a company really maintain a strong culture even during those union negotiations or disputes? Because people, they're on each side of the fence, and some are saying, well, don't unionize because it's going to hurt us. And it's not so easy, right? How do you, as a leader, keep the right kind of face? Because you've got two sides pulling against. One, somebody's trying to pick your pocket, and the other side is, you don't want to go down, right? Because it may cost you more than it's worth.
Absolutely. I absolutely believe that companies can maintain strong culture even during this process in this organization. It is true that unions often, come when there is a crisis within an organization, or some level of discontent, but there are absolutely many, many organizations and industries where the unions work side by side with the employer. I think there are inherent adversarial pieces of that relationship, the same way there is between any employee-employer. But that doesn't mean it has to be combative. That doesn't mean that it has to be disruptive. And we've seen unions do a lot of good. My mom was in the teachers union. I'm not anti-union. Unions are why we have weekends. They're how employees had protections before OSHA or Title VII. And then all of that employment litigation and the statutes that were passed kind of balance things out. And so that's why we see unions in some industries and not others. But absolutely, I think that taking a respectful, collaborative approach, but continuing to maintain the line on what is management discretion is not always easy, but it's definitely possible. And I think we're seeing it more and more.
You go down through it and, we got AI, distributed teams. And here's another thing. How is this going to work? We didn't talk about that much, but as AI enters HR hiring and does the work, how, in performance evaluation, what are the risks? what if it hallucinates and makes something up? I mean,
Yeah.
legal
No,
risk
it's
emerge.
it's a great question. I had a case several years ago where, a non-AI but computer glitch sent an email to an employee that they were fired because they were out of leave time, and it was a big deal. I think we are going to see that if we take the human element out, and kind of routinize our HR decisions and discussions. I have also seen in the very early stages chatbots coming in for HR requests. And I have some trepidation about that, right? Because I know that I have been on the phone yelling representative trying to get somebody. And I can only imagine if it's my job and not trying to return something, I might feel even more strongly about needing to talk to a person in a timely manner. So is there room for AI? Absolutely. But are we still figuring it out? Even more so. I think we've talked about discrimination concerns with AI, just confirmation bias, things like that. And then also employees' use of AI is a growing area, right? What are you as a company doing to make sure that employees are protecting confidential proprietary information, not misusing other protected information, and following company guidelines? So we've got a lot coming up with AI that we're all still working through.
When companies, what companies should consider when employees no longer sit in the same state or the same country, right? Because a lot of people,
Mhm.
they're getting their engineers from places like Vietnam or India, and you've got a whole different realm, right? A whole lot of other things to think about. So what should these companies consider when those employees aren't there with them, or they're not in
Absolutely.
California, they're in Florida, or they're not in California, they're in Bangalore.
Mhm. Absolutely. I think registration requirements are one of the number one concerns. And in the US, that's things like workers' comp and state taxes. And if you're going to other countries and internationally, that can also just be being licensed to do business. EORs can be very helpful if you're looking to source service providers from other countries. And I will tell you, employment law varies significantly between jurisdictions. US employment law is not the standard everywhere. So getting local counsel, getting an EOR, super, super important for anything international. And then I think that also comes with, more practical administrative concerns like, do you have core business hours? How are you working across time zones? How are you protecting information and making sure that your communications are secure? So that's all really important. And then another thing for within the US, there's a lot of local laws, and I think more and more, depending on what states you are hiring employees into, you need to look at the local requirements, right? Does your PIIA, if it has non-compete or other restrictive covenants, does that need to be updated based on where the employees are located? Are there sick leave requirements or other requirements? So it gets trickier, and it can become a really complex web of laws that you're navigating. And I would suggest counsel and EORs for that expansion.
So looking ahead 5 years, what major shifts in employment law should executives prepare for today?
It's a good question. So I think we're going to see more remote hybrid work. To what you were just talking about, we are continuing to push to national, global, right? And I think that gives companies the ability to source talent, and it gives individuals the ability to live where works for them. I think that's already an issue we're seeing, but I think that's going to continue. And so figuring out how to be flexible. I always sound like a boomer when I talk about Gen Z, but I think, as Gen Z becomes more integrated into the workforce, seeing who comes next, we're seeing that priorities are changing. There's just changes in work-life balance, job expectations, how we manage that. I did intergenerational workplace training when I first started as a lawyer, and I thought it was the most interesting, training course I ever took. Just kind of, it was all broad generalizations, but it was really interesting, and I do think it helped frame how people can work together.
What was
And
it,
then I think,
Andrea, when you did the training? What
uh-huh.
was the things that was like an aha moment that you saw between the boomers and Gen Z, for instance? What were some of the differences? Mentally, what were the difference between the two of them?
So they defined each generation based on the biggest events that had happened and how those events had shaped people's values. And so it was the boomers had this value of providing, and by the time you got to the millennials, the values were much more individualized, and it was much more about yourself as opposed to the family-based values, and seeing how that moved was really fascinating.
Is that good or bad though?
Probably both.
It's interesting though. It's you look at it because remember growing up, it was a different world though. We didn't have the knowledge that we have now. I mean, we have everything. Here we are, right? I remember going to Disney, to the Epcot Center, and seeing this stuff exactly the way we are right now. In Epcot, it was incredible. And here we are doing a Zoom call, right, or StreamYard, and you do it every day, and you just take it for granted now.
Yeah, absolutely.
Yeah. So, hold on. I think so. I hear a noise in the background. It sounds like somebody's calling something. It's gone now. So, closing statements. Let's look at it. What is the most expensive employment law mistake you see CEOs making, and how can they avoid them?
Yeah, absolutely. I think it's skipping steps in the beginning and then, thinking you'll get around to it and not. And so I will say being proactive beats being reactive 11 out of 10 times. So get yourself a lawyer who can take the time in the beginning, get things set up right. And then, you don't have to think about it again, hopefully, knock on wood, but just get it set up right in the beginning so that then you can get back to business.
So how do we go down through, and how does a firm like Pillsbury help transform employment challenges and strategic advantage for rapidly scaling companies?
Yeah, so Pillsbury is a full service law firm. So we are able to take you from day one, from, incorporating through your offer letters, your documents, defending you if there is litigation, whether that's small or large, and then through any transactions and buy or sell. So I think one of the really important things and the special things about a place like Pillsbury is that we have the ability to see the whole picture, and that is really, really helpful. I'm on a deal, and we had a call earlier this week where there was a specialist at a different firm who was very upset because he thought that these issues had not been addressed, and he wasn't wrong, but the issues had been addressed because we had thought them all through, right? And so I think it's when you have a firm that can do it all and can have that bigger context, it can be really helpful. It's your one-stop shop, and you're getting advice that's not in a vacuum. You're getting advice that takes into account everything you've got going on.
Well, I just we're coming to the end of the show. I just want to say I love Pillsbury and the kind of things that you've done for myself and my company. It's incredible, and you and Stan and the whole team are just amazing. So, with that, where can founders and leaders go to learn more and to reach out to you? Directly?
Absolutely. If I can provide my contact info, I will. It's just, we don't get us confused with the Doughboy. It's Pillsbury Law. I've had people try to find me, Andrea at Pillsbury, and if there is an Andrea in their legal department, I'm very sorry, but it's andrea.milano at pillsburylaw.com. You can find me on the website. You can find me on LinkedIn. I'm happy to help with whatever needs you have and whatever you've got going on.
Andrea, thanks for taking time out of your busy schedule to join us today. It's just fascinating, and really appreciate it. It opens up a different world. And to all the startups out there around the world, if you have some issues with employment law, if you have some issues with ADA compliance, reach out to Andrea. She's an amazing, amazing lawyer and can provide you with a lot of information and help. So thank you very much. So to all of you out there, stay happy, stay safe, and stay healthy. And I'll be back to you again soon with another exciting edition of GSD Presents Top Global Startups My name's Gary Fowler, and I'm your host. Thank you. Thank you, Andrea.
Thank you.